the first to know Nsem-Pii TV.
Sir, Jebekaya Enche and former Chief Justice Yemami Torkono na ono Chief Justice John Dramani Mahama Nsa aka petition de free nipa miensa bi ho a eno enam so a ono ekokote committee committee no Justice Puaman na eda committee no ano 181 report na die na ha adwen wo mu se report miensa committee no etena asese wo hwem no ba ko pe na committee no ehwem na ode bre president se onhwan Chief Justice to akonwa na asem no nimiapa na enye asem kotwa already Yamame Gertrude Araba Isaba Torkono de asem no akopie mu ewo ECOWAS court na enenso wasan akopie mu ewo Supreme Court se John Dramani Mahama elaki jurisdiction se onu ebetimi ayi no as a Supreme Court judge although se obetimi ayi no afri wo se onu enye Chief Justice bioba se oye Supreme Court judge de John Dramani Mahama nisa power no se obeyi no nioma 4 ena okokopie mu court no osiki bako ena makacho de toso miensa eye de yenkonyenkonkotie.
Former Chief Justice Gertrude Araba Torkono is putting up a fierce legal battle against her dismissal as a justice of the Supreme Court. She argues that the president overstepped his authority by not adhering to the constitutional procedure outlined in Article 146. She's seeking to have the presidential warrant of removal squashed, deeming it unlawful and void. Well, let's give you more on this. Join me in the studio is Caleb Zublim of our research desk. He joins us. Just tell us more of this petition. What exactly is she seeking?
So the removed Chief Justice has gone to the High Court and she's seeking 4 main reliefs. So let's go to the release first. She wants the court to declare the president's power, to declare that the president lacked power to remove her as a judge. So she has considered that the president could remove her as a Chief Justice, but not as a justice of the Superior Court. So she has considered that, yes, you can remove me as the Chief Justice, but not as a judge at the same time. So that's the first relief being sought. Now, the second is declare that only Article 1464. Now, this is the part of the Constitution that outlines how you remove a justice of the Superior Court, not a judge, and also quash the president's removal warrant. So now we understand what she's looking for. We have to understand why she's looking for this. So she says that the petitions that were submitted, I remember 3 petitions were sent. One by Daniel Ofori, one by a police officer, and by Shining Stars. So these 3 petitions, she says that all of them were for her removal as a Chief Justice, not a Supreme Court Justice. So all the petitions that eventually went to the Council of State, and the Council of State found the prima facie based on the petitions, which were again as removal of Chief Justice and not a Superior Court Justice. She also says that when she knows she has to respond to her, when she went for the committee hearings, she also wrote a response to the presidency and the Council of State. Her response was defending her position as a Chief Justice and not as a Superior Court Justice. So it would be unfair for them to remove her as a Superior Court Justice as well as that. And also, I've already touched on this, that the Council of State prima facie decision was only for the removal of a CJ and not a Superior Court Justice. Then again, the committee that the president set up, the 5-member committee, and was set up based on the grounds to remove her as a Chief Justice and not Superior Court Justice. And if you want to remove a Superior Court Justice, a committee will be set up by the Chief Justice and not by the president. So she says that this committee was not set up. And if this committee is not set up, you cannot remove her as a Chief Justice, as a Superior Court Justice, sorry. And then finally, the committee could not recommend removal as a Superior Court Justice because this committee was created to remove her as a Chief Justice. And if you want to remove her as a Superior Court Justice, you have to follow the steps in the Constitution to set up a different committee that will be constituted by the Chief Justice to preside over that issue.
Thank you, sir.
The bar president here, Mrs. Ifo-Agate, and the Attorney General here, Dominic Ahini, clashed and locked horns at the bar conference over matters of Article 146. Now, the Attorney General spoke first, I believe, and he was concerned that the bar is raising issues about the Article 146 process that removed Gertrude Torkono, and that he thought that they are being self-serving. That was a word he used, very harsh. And he also thought that they are being selective because, according to the Attorney General, when Article 146 processes were applied against the former Shraj boss, Lamte, I forget her first name, and is it Matilda? Something Lamte. And it was also applied against Charlotte Osei in 2017. He, the Attorney General, says he doesn't remember the bar making any statements about it. He wonders why, therefore, that Article 146 is being applied again against Getru Torkono, and it becomes a problem. So that was what he said. But there was a lot more infighting and controversy about the bar conference. After the Attorney General spoke, he left. He didn't continue to sit at the bar conference. He left. We don't know what to make of it. We don't know what we should say. It suggests that he was quite angry, or there's bad blood, or there's concern about difficulties in relationship between the Learned Attorney General, who is the leader of the bar, and the Ghana Bar Association, which is led by Ay3de. We'll dig into that and give you some more information. But all the lawyers said that after that Attorney General left, which is unprecedented, is sufficiently uncharacteristic. But we don't know why the Attorney General left. He may have had a very good reason for doing so. But he left the bar conference. And Ay3de and the rest are still continuing. It's a 1 week long activity. So they are still in Wa doing the bar conference. Let's begin with what the Attorney General said. This is what he said.
Immediately upon assuming office in 2017, an Article 146 petition was filed for the removal of the chairperson of the Electoral Commission, Mrs. Charlotte Osei, and her deputies from office. The bar saw no basis to speak out about compliance with due process. But in recent times, the bar found its voice when petitions based upon the same constitutionally defined procedures were brought in respect of the removal from office of the former Chief Justice, Mrs. Gertrude Torkono. Ladies and gentlemen, the honest question we have to ask ourselves is, what changed? The three petitions aforementioned touch and concern office holders of three constitutional bodies critical to the sustenance of our democracy. The independence of the three institutions has been guaranteed by the Constitution. The three occupants were all women of significant repute and members of our noble profession. The three committees established pursuant to Article 146 complied with the constitutional procedure to the letter. And yet, the bar found its voice only in relation to the third petition. Coincidentally, the voice of the bar amplified the voice of the opposition. The lawyer in politics must be a voice of reason, moderation, and constitutionalism. The bar must speak out not to please governments or opposition parties, but to defend the rule of law, the independence of the judiciary, and the rights of the ordinary citizen.
The Learned Attorney General said that the Bar Association, I'm not sure whether the Learned Attorney General at the time he read his speech was aware that the Bar President was going to talk about the what the Bar considers unfair in the processes that remove Getru Torkono. But let's listen to what the Bar President said. Here it is.
The Constitution of the Ghana Bar Association enjoins us to protect the independence of the judiciary. This is a duty the association does not take lightly, and from time immemorial, the bar has fiercely performed this duty. My learned friends, we are all aware that Article 146 of our 1992 Constitution has come under severe scrutiny in recent times. For the first time under the Fourth Republic, it's been evoked in respect of a Chief Justice. The position of the bar must be stated clearly in this regard. The bar recognizes the fact that the power of removal can be exercised under Article 146, but the bar's major concern relates to the process. In the absence of specific rules of procedure, the sketchy process potentially lends itself to arbitrariness and a lack of fairness. Hence, the bar's resolution on the matter, which was as follows. The Ghana Bar Association hereby also calls for the immediate enactment of clear and comprehensive regulations relating to matters under Article 146 of the Constitution of the Republic of Ghana to ensure transparency, accountability, and fairness in all proceedings involving Superior Court justice, particularly in the context of the impeachment or removal of such officers. This resolution was passed and publicized by 30th April 2025. However, no rules were produced. It is commonly said that justice should not only be done, but manifestly be seen to have been done. The lack of an enactment for such rules in the case of the removal of the fourth highest person in the nation should be a matter of concern for all of us. These rules should have been known to all and sundry before the commencement of the process, as it greatly affects the standard to be met. It ends up being an unfortunate precedent which lacks fairness, a situation that calls for redress if indeed we are custodians of justice. We all deserve justice, from the well-endowed in society to the less endowed, from those who wield political power to those who don't, from those who have economic power and those who don't, from those who dispense justice to those who receive.
So the bar president actually read a resolution from the entire members of the Ghana Bar Association, and therefore the criticisms of the Attorney General should be looked at as criticizing the bar, of which the Attorney General is a leader. There's a lot more to say about that, but if you have some information on why the Attorney General left the bar conference after giving his speech, which we are told by lawyers is unprecedented, you can tell us, because the lawyers are still at the bar conference, some of them may be watching, you can tell us why, if you have that information. Apparently the Deputy Attorney General, Justice Nsem-Pii, was not seen at the bar conference at all. Let's now get to the bench, because the bar conference is not just about the Ghana Bar Association, but it's also about the bench, all of whom are members of the Ghana Bar Association. Justice Yoni Kulendi was at the bar conference. Oh, can I? Yes, Justice Yoni Kulendi was at the bar conference, and then there was also other judges. I believe this was a judge that represented the Chief Justice. This is Justice Gabriel Scott Kwamine, and this is Justice Jamefe. This is Justice, I have to get his name. But this is the issue. Justice Bafuboni, if you can give me Justice Bafuboni's photograph, it's very important. Justice Bafuboni is the acting Chief Justice. He did not attend the bar conference. Justice Bafuboni did not attend the bar conference. He sent somebody else to attend the bar conference. If you can give me the photograph of the Supreme Court judge, my lady who attended the bar conference for Justice Bafuboni. Now, there she is. She attended the bar conference. She represented the Chief Justice at the bar conference. Now, there's a bit of gossip around this conversation. I'm going to share with you. Justice Bafuboni is the acting Chief Justice. Yeah. Recently, he traveled, and no, certainly not. Please, please. Okay, this is Justice Bafuboni, who is the acting Chief Justice. Your Lordship, good evening. Now, Justice Bafuboni is an acting Chief Justice. He recently issued a public notice that he was traveling and that he will be replaced by Justice Gabriel Kwamine, who was the next senior most. This is the letter that said so. They put it out like this. Okay, now this is the letter that says so. So the letter says that away from duty, it's 13th August 2025. It says, I shall be away from the jurisdiction from Monday 18th August to Thursday 28th August 2025. I am, in my absence, the most senior justice of the Supreme Court. His Lordship Justice Gabriel Kwamine will act. Please accept my compliments, etc., etc. Justice Paul Bafuboni, acting Chief Justice. So Justice Bafuboni sent us this letter, general public. Now, yesterday, he was not able to attend the bar conference. It would have been easy if Justice Scott Gabriel Kwamine was representing him and reading his speech at the bar conference. Every bar conference, the Lord Chief Justice speaks. So we all knew that the Chief Justice was going to speak, and we wait for what he's going to say. So Justice Bafuboni did not attend the bar conference, and he did not send Justice Gabriel Poaman to attend the bar conference. He sent the lady Supreme Court judge, who, according to the Pagan order, is the junior most Supreme Court judge. She's the one who was sent to represent the Chief Justice at the bar conference. Justice Yoni Kulendi, a fairly senior Supreme Court judge, was at the bar conference, but he was not asked to represent Justice Bafuboni, the acting Chief Justice. This is a bit of gossip that lawyers are having this conversation around that. But why didn't the Chief Justice send one of the senior? Why did he send the young the Supreme Court judge, this lady who went in there to represent the Chief Justice? Now, my lady, good evening. Now, the video here will confirm that she represented the Chief Justice. Let's just watch the video to confirm that she did, and then we come back and finish up the analysis. This is what she said.
I bring you warm greetings from His Lordship, Justice Paul Bafuboni, Acting Chief Justice of the Republic of Ghana. His Lordship is unable to be here in person due to other pressing engagements, so he has delegated me to read his address today.
That's Justice Hafisata Amali Boba, her ladyship Supreme Court judge, who represented Justice Bafuboni. So viewers, you get the drift of the matter. Justice Bafuboni is the acting Chief Justice based on the fact that he's the most senior most. In fact, there's a bit of jurisprudential conversation about this, whether the letter that Justice Bafuboni wrote for Justice Gabriel Poaman was valid, because Justice Bafuboni is acting Chief Justice under a constitutional provision. The 1992 Constitution provides that where the Chief Justice is unable to perform his or her functions, the next senior most judge will replace him. That's where the Constitution ends. The Constitution does not proceed to say that if that next senior most judge is also not able to perform his function, it should be the next. We can presume it, but the Constitution really doesn't say that. And so Justice Bafuboni handing over to Justice Gabriel Scott Poaman was debated in legal corridors whether it's a proper thing to do. You know, they are constitutional purists, and they like to talk about these things, and I won't mention their names, but you know some of them. They are constitutional purists. So that's a different matter, but that conversation was had. Now, though, Justice Bafuboni then sends Justice Hafisata Amali Boba to the bar conference to represent him. So Justice Yoni Kulendi is at the bar conference. He doesn't get to represent the Chief Justice, even though he's senior on the Supreme Court, as far as Supreme Court is concerned, to Justice Yoni Kulendi. He's senior to Justice Amali Boba. Somehow, Justice Amali Boba is the one speaking for the Chief Justice. And what did the Chief Justice say? The Chief Justice drops a bombshell, which is a big part of our program tonight, about Galamsey. He had very harsh words for the government about Galamsey. Now, where is it coming from? It's evolving from the president's press conference, and I really don't know what the communication people at the presidency are feeling about this press conference, because before the president's press conference, there was not much pressure on the government about Galamsey. After the president's press conference, based on the answers the president gave, all hell has broken loose, pressure on the government about Galamsey. So I'm not sure how they are taking this, whether they should have done the press conference or they should have left it. Anyway, that's a conversation for another day. So let's see what Justice Bafuboni told the world at the bar conference through Justice Amali Boba. Let's see some of the slides. One of them is this. This one is very serious. It says, Justice Bafuboni, speaking at the bar conference, says, how did we get here as a nation to allow a few selfish and greedy individuals connected to power and influence in society hold the entire nation and its future to ransom for their benefits? That's very strong. Now, I should have told my people to get a video of President Mahama answering. If you can quickly get that, it's important. President Mahama answering the conversation. I don't know whether it's going to be part of Miracles' presentation, but if you have the video, let's signal me when you have it. Okay, let's see what President Mahama said. Before then, though, what's the... if you have the video, let's get it. I mean, use it. Check whether you have it. Now, what did President Mahama say? What happened at the event? He was asked a question by Joy FM's Koje Jackson, who asked him that, your gold board, do they know what gold they are buying? Are they buying Galamsey gold or they are buying this? President Mahama's conversation was that a state of emergency is a last resort issue. You cannot do a state of emergency because it has major economic implications. He also said that there are 4 million people working on Galamsey, that if you stop Galamsey today, what are the 4 million people going to do? President Mahama was attacked on Facebook. Many people said that, what is he talking about? Does he mean that, what about armed robbers? If they catch armed robbers, are we going to say that they are doing armed robbery and they are doing armed robbery because we don't have a job for them. President Mahama said that we should create something for them and then we can ease them off Galamsey. So questions were being asked. Galamsey is an offense. It's a crime. It's a criminal activity. Are you free to pursue a criminal activity because you have finished school and you are unemployed? Are you free to pursue any criminal activity because you're a young man and you're unemployed? These are the questions people were asking President Mahama, that if you say that the Galamsey people, we should find something for them before they move. The Galamsey that they are committing, destroying water bodies. I heard something very frightening, that the Volta Lake is also being affected by the same illegal activity of mining in forest areas and mining on water bodies. So this became a big deal. Just for recap, this is what President Mahama told the media last week. Just for recap, this is what he said.
I never expected, or I never deluded myself that the fight against illegal gold mining or Galamsey was going to be an event. The Gold Board was introduced as part of reforms. And if the Gold Board was not introduced, I mean, those who were taking the profits from the small-scale mining sector were the foreign traders who were taking that money away. In 6 months, we have exported over $6 billion. About $4 billion of that money was going to go into the private or foreign traders. And so the first thing is you shut the stable door so that the horse doesn't escape, which is what we've done. So if it's from illegal sources, it's from legal sources. At least it's our land that is being destroyed. So let us get the benefit of it instead of foreign traders. So that's the first thing. I've been reluctant to implement a state of emergency in the Galamsey fight because we've not exhausted the powers we even have without a state of emergency. We have the opportunity to arrest anybody, to confiscate any such thing. There are laws for forest protection and all that give us enough powers to be able to act. Implementing a state of emergency might sound nice, but it should be the last extreme, the last resort. So for now, let's exercise all the powers we have. And if it becomes necessary for a state of emergency,